Okay, I think we can go ahead and start. Welcome. My name is Andrew Ridland, and I'm a Murphy Scholar, and as well as a joint degree student for both the Master's in Catholic Studies as well as getting my law degree from the St. Thomas Law School. On behalf of the Murphy Institute, allow me to express our gratitude for you joining us today. Today's webinar is focused on the future of American abortion law. Will Roe survive to see 50? This webinar is part of a series of webinars hosted by the Murphy Institute and offered by St. Thomas faculty. There's a wide range of topics that we cover in these webinars, including the meaning of work, racial equity, religious liberty, and even building community was our last one. The structure of today's webinar will consist of roughly 40 to 45 minutes of us hearing from Professor Collett, followed by a time for a question and answer. When that time does come, you should see a Q&A button appear at the bottom of your Zoom screen. And a few other notes. Today's webinar has been approved for CLE credit. If you didn't see the email earlier, feel free to reach out to Michelle Rash and she can help make that happen. Also, today's webinar is going to be recorded. So today we're joined by Professor Teresa Collett, which is a special treat for me because I just had her as my property professor in the fall. And Professor Collett has done a lot in the area of pro-life work and fighting for the right for life. So Professor Collett is the director of the law school's pro-life club. She has published numerous legal articles as well as co-authored a law casebook on professional responsibility. And she was the editor of a collection of essays exploring Catholic and Catholic perspectives on American law. She is an elected member of the American Law Institute and has testified before committees of the U.S. Senate and House of Representatives, as well as before legislative committees in several states. In 2019, Pope Benedict XVI appointed Teresa Collett to a 5-year term on the Pontifical Council for the Family, and that appointment was renewed by Pope Francis until 2016. And finally, this is not something that you will see on her resume or on a website bio, but something that I experienced in class with Professor Collett this past semester is that she is extremely gifted in engaging individuals who have opposite or opposing viewpoints, meeting them where they're at, and then walking them towards the truth. And I think that's very admirable in someone who is on the front lines of this issue of abortion in our country. So without further ado, I'll hand it over to Professor Collett.
What a lovely introduction. Thank you, Andrew. And the grades are already turned in. So actually, it was a pleasure having the students I had last semester because it's a really trying time for lots of people. And it was just a joy to teach our first year students last semester. This semester, I have the opportunity to teach bioethics. And as Andrew mentioned, I'm the director of the law school's pro-life center. We also have a pro-life club, which is our Lex Vitae club with students who are active and who often volunteer on various things regarding preservation of and protection of human life. So with no further ado, I'd like to share a PowerPoint with you all to sort of guide us through our conversation. No doubt many of you have already heard about sort of the dire predictions that Roe is going to fall. And we certainly saw them in the confirmation hearings of our two most recent appointed Supreme Court justices. The first, of course, with Justice Kavanaugh and his interrogation prior to the allegations of misconduct. And then we didn't see it quite as much with Justice Amy Coney Barrett in her Supreme Court confirmation, but that it certainly was a continuing theme when she was confirmed for her Court of Appeals seat that was perhaps made famous or infamous by Senator Feinstein's question related to how deeply the dogma lived within her. And I don't think that was a completely unfair or ridiculous question, simply because it is a fact as we saw with Justice Kennedy and with other justices, that the foundational views we have of the world about the nature of human person and the value and dignity of each human person influence the way we see the law and influence the way that we believe the Constitution should properly be interpreted. So let me begin with sort of that premise. As I said, I'd like to share a PowerPoint that I'm using as we go through this to sort of talk a little bit about where I think we are. But to know where we are, we have to know where we've been. So as you can tell by my title of this particular slide, Roe versus Wade, notwithstanding it's reached the august age of 48 years, was really a very odd case in the way that it came to the US Supreme Court and that the way it was ultimately resolved. In fact, it's been heavily criticized by both people who believe that abortion should be a constitutionally protected right, and people who, like myself, believe that the Constitution does not create or protect a right to abortion. So let's go back to the very beginning of this case, the case that came out of the Northern District of Texas. And the issue was raised in the context of a woman, Norma McCorvey, who was allowed to proceed and anonymously under the name of Jane Roe. And she challenged the Texas abortion statute at the time that criminalized the performance of most abortions in the state, all of those that were not necessary to prevent the death of a woman, on the basis that it was constitutionally vague and on the basis that it violated her Ninth Amendment rights. The trial court proceeded very expeditiously in the case and in fact disposed of it on a motion for summary judgment. The lawyers that are watching this video know that in fact that means that there was no significant discovery in the case. There was no strong evidentiary presentation or record for the appellate courts to review. But rather the district court said that as a matter of law, the Texas statute was unconstitutional and it didn't really need to look at the facts. But yet, at the time, the court also said that it would not enjoin Texas authorities from enforcing the law because of the federal doctrine of abstention. Now, abstention will be a concept that will seem rather foreign to our non-lawyer viewing audience, but the Supreme Court, while the Roe trial or the Roe case was initiated, was still struggling to articulate when it was appropriate for federal courts to intervene in state criminal proceedings and when it was appropriate for them to provide injunctive relief to the plaintiffs in those cases. And there's been a lot of cases where that question had been raised in the context of the civil rights movement, where there were state courts in states that were simply disregarding the rights of free speech, the right of free assembly, the right to protest. And so it was a question that was a live question in the courts at that point in time. And interesting enough, prior to accepting Roe versus Wade, the court had a case before it called Younger v. Harris, and that particular case provided a lot of clarification on the role of federal courts in addressing the constitutionality of state laws. In addition to sort of the anomaly of the trial court saying the law was unconstitutional but refusing to prohibit its enforcement, there was another anomaly in the case, in that the appellate procedure rules embodied in US statutes allowed direct appeals to the US Supreme Court based upon the granting or the refusal to grant declaratory relief, but did not allow direct appeals based on I'm sorry, did not allow direct appeals based on declaratory judgments, but did allow it on the basis of injunctive relief. So the question presented to the Supreme Court was whether the trial court erred by denying the injunctive relief based on the Supreme Court's decisions of the abstention doctrine. The actual ruling that the statute was unconstitutional, that declaration, an appeal was pending in the Fifth Circuit for that determination. And it was that unique combination that the trial court said, yes, your law is unconstitutional, but no, I'm not going to prohibit its enforcement, that caused this odd dichotomy with the substantive judgment being appealed to the Fifth Circuit, with the remedy portion being appealed to the US Supreme Court. So on our next slide, we sort of see some of the chronology of this. On February 23rd, 1971, the Younger v. Harris opinion was issued by the court, and it resolved a number of the questions about federal court interference with state court proceedings and with state laws. And it was on that basis that Texas, in the Roe v. Wade case, said, court, you don't need to hear this direct appeal from Jane Roe. Rather, you need to just leave it in the Fifth Circuit. But instead of doing that, the court had already voted to hear Roe versus Wade and Doe v. Bolton. But they simply, in a one-sentence response to Texas's position, said, we're going to hold the procedural questions until we actually reach the merits. So again, what makes this case odd in a number of ways is, first, it's a major constitutional decision with virtually no evidentiary record. So all of the facts related to abortion come in through amicus briefs at the Supreme Court level. And second, it's a case in which there's no intermediate court of appeals decision. You've got the opinion of the 3-judge district court panel, but typically the Supreme Court waits until you have an appellate opinion, as well as opinions in other courts of appeals, to sort of see some of the questions that come up and the way the different courts answer those questions. Many scholars, as I note on this slide, attribute the decision to disregard the appellate procedure to the desires of Justices Brennan, Douglas, Marshall, and Stewart, who wanted to legalize abortion. And not only did you have 4 of the 5 justices initially strongly supportive of expanding what they called the right to privacy in the contraception cases into the field of abortion, but then in September 1971, after the case has already been accepted for review, Justices Harlan and Black retire from the court. So now, instead of a 5-4 majority to avoid entanglement in the political issue of abortion, you have a 4-3 majority to legalize abortion as a matter of constitutional law. So there are a lot of odd things, and it shows that people matter. That absence of those 2 justices, notwithstanding that the seats were subsequently filled, allowed the preliminary oral argument to be heard, allowed the drafts of the opinion to be circulated. And so it had a tremendous influence on whether or not Roe overturned the abortion statutes throughout the country and the breadth by which they did, including virtually deregulating abortion in every way up until the point of viability. And even at the point of viability, most scholars read the Doe v. Bolton case, the companion case that came out of Georgia with the Texas case, as saying that that limitation at viability, that abortions could be prohibited except for cases involving the life or the health of the woman, uh, was so broadly interpreted that it included the emotional health, the age of the woman, the marital status of the woman, that essentially it became the exception that swallowed the rule. So Roe v. Wade was a product of the unique combination of both historical events as well as the personalities and political views of the judges sitting on the court at the beginning of Roe, where they accepted a narrow procedural question, to that time period where argument and briefing had been provided, but the court was operating shorthanded, to the final resolution of Roe after a second oral argument, and the issuance of the opinion when the court had 9 justices sitting. Well, we see a similar sort of odd shift in the political balance and in the judicial review of abortion law in Planned Parenthood versus Casey, which is uh, after the Webster opinion a few years earlier than Planned Parenthood versus Casey. Um, the court's really first opportunity to articulate a sounder constitutional basis of what it had declared to be an abortion right. And there is an author, Mr. Tubin, who wrote a book called The Nine about the US Supreme Court, and sort of tries to provide a historical insight into what's happening during this time. And here's how he describes what happens during the Planned Parenthood versus Casey appellate review. He says, once, before Justice Kennedy joined the court, he had called Roe the Dred Scott of our time, a reference to the infamous 1857 ruling that sustained slavery and helped spark the Civil War. Kennedy thought, and I'm having difficulty seeing my slide, so I can't read it. Oh, I'm sorry. I can't read it directly. But Kennedy thought there was nobility in judging. Saving Roe would show the world that the justices were more than mere pawns or politicians. A statesman-like compromise suited both Kennedy's view of politics and his conception of the role of judge. So Kennedy signed on to what became ultimately the plurality opinion of Planned Parenthood versus Casey with Souter and O'Connor. It was that opinion, that plurality opinion, that reestablished the constitutional moorings of Roe versus Wade, although many scholars still believe that they didn't find any substantial constitutional authority for the ruling, but instead relied on the position that Roe versus Wade had been so incorporated into the daily life of the American populace that stare decisis counseled against reversing Roe. His was the most surprising switch of the three because it had been only 3 years since he'd joined Justice Rehnquist in Webster, an opinion that actually did advocate overruling Roe, not the majority opinion, obviously. And even more dramatically, Kennedy had clearly supported Rehnquist at the conference after the oral argument in Casey. At the conclusion of the initial conference on the case, Rehnquist, believing he had the support of Justices White, Scalia, Thomas, and Kennedy, assigned the Casey opinion to himself, intending to write an opinion that allowed states almost a free hand in regulating abortion. As a practical matter, Roe would be overturned, but not in so many words. So again, we see that shift from a 5-4 opinion that we saw in Roe versus Wade when it was accepted to majority opinion legalizing abortion throughout the country. Here we had an initial conference where once again we had 5 of the Supreme Court, 9 Supreme Court justices opining in the private chambers of the court that Roe was not constitutionally compelling and therefore that it should be overruled. And yet Justice Souter, at least as Jeffrey Toobin tells the story, as an advocate for reformulating the foundations of Roe, but not overturning it, began to work on persuading Justice Kennedy and Justice O'Connor to join him in writing an opinion that would preserve Roe, but would recognize a greater authority of the states to legislate in this area. Now, why do I tell these stories? Well, because I want it to be really clear that those of us, both on the pro-life and the abortion rights side of the debate, that believe that Supreme Court judicial appointments are crucial to either reversing or maintaining Roe versus Wade, are well founded just in the history of the two major cases in the area. From there, when Roe came out, it created a firestorm. And so during the time period between since 1973 to today, there have been more than 330 constitutional amendments introduced into Congress, including 37 House resolutions that would provide a constitutional amendment by the Minnesota congressional delegations, at least in the early period after that. Those sorts of amendments, though, are not all the same. Just as when we look at state constitutional amendments, there's a wide variety of sort of amendments related to Roe versus Wade. The first type is what we call life protective amendments that provides explicit protection for the unborn. It says that the right to life of the unborn shall be protected. Alternatively, Senator Jesse Helms at one point introduced an amendment that declared that the right to life for each human being from the moment of fertilization is a paramount constitutional right in the Constitution, thus having it prevail if it came into conflict with a right to privacy or some other constitutional right. There have been amendments proposed that outright prohibit Roe versus the performance of abortion in the United States, as well as personhood restoration amendments. Those amendments simply declare that every human being shall be deemed from the moment of fertilization a person under the Constitution. There have been reversal amendments or abortion neutrality amendments, and that's actually what we're seeing advance in some states this year, where the state constitution will be amended to simply say a right to abortion is not secured by this Constitution. Why I call them abortion neutrality amendments is simply to say that the Constitution's neutral on the issue, and so the legislature may act in this area in whatever manner it sees fit. And those look a lot like state legislative amendments that have been proposed for the federal Constitution, which simply recognize the constitutional right of individual states to legislate on the topic of abortion, including its prohibition, its regulation, or its support, like we see in the state of New York right now under the Women's Reproductive Health Act. So there was a lot of activity and has been a lot of activity regarding constitutional amendments, but only one model even made it to the floor in Congress. In 1983, after 2 days of debate, the US Senate rejected the Hatch-Eagleton Amendment. The proposal was an abortion neutrality amendment, but notwithstanding that, it was able to garner only 49 of the 100 votes, and passage of such a proposed amendment would require 2/3 vote. So it actually failed by 18 votes at the time. That's not the only efforts that we've seen at the federal level, though. Between 1983 and 1992, the US Solicitor on behalf of the President of the United States has asked the Supreme Court to overturn Roe 4 times. Each time it was rejected. And perhaps most recently, in the June Medical versus Russo case, there was a brief filed on behalf of 207 members of Congress requesting that the court uphold the Louisiana statute requiring admitting privileges prior to the performance of abortion. And I quote from the brief, take up the issue of whether Roe and Casey should be reconsidered and, if appropriate, overruled. So this is an area where there's been a lot of activity, and these are simply the executive and legislative responses. There have been well over 40 cases brought to the U.S. Supreme Court that have been accepted, and many, many more that have been appealed to the U.S. Supreme Court from regarding state statutes where the states have tried to induce the court to reverse Roe versus Wade. Well, at least this past year, President Biden seems to believe that the overturning of Roe versus Wade is a real possibility, especially with the additions of Justice Gorsuch, Justice Kavanaugh, and Justice Barrett. And so, in his briefing statement on the 48th year of Roe versus Wade, the president and the vice president joined together in making the following statement. In the past 4 years, reproductive health, including the right to abortion, has been under relentless and extreme attack. We are deeply concerned and want to make sure everyone has access to care, including reproductive health care, regardless of income, race, zip code, health insurance status, or other status. The Biden-Harris administration is committed to codifying Roe versus Wade and appointing justices that respect foundational precedent. Well, whether it's foundational precedent or not is a highly debated topic, and a topic that every justice since Justice Ginsburg has often declined to opine on during their confirmation hearings. But nonetheless, it is precedent of the Supreme Court. And so the question becomes, are these fears about the overruling of Roe versus Wade simply phantom fears, or are they realistic? And for that, I would note that the Supreme Court has reset for conference multiple times an opinion out of Mississippi in which the question is whether or not a 15-week abortion ban is constitutional. Dobbs versus Jackson Women's Health continues to be held by the U.S. Supreme Court for conference, which suggests that there's at least a vigorous conversation among members of the court as to whether or not they want to hear that case. And if they were to do so, it would be in this upcoming term, which then the opinion would be rendered very close to the anniversary of Roe versus Wade. So President Biden's statement, is that just a false threat as well? Unfortunately, I don't think so. In fact, we just saw this week the passage of by the House of a pending piece of legislation called the Equality Act. And while the Women's Health Protection Act of 2019 has not been passed by either house, it certainly remains an active piece of legislation that we can anticipate being used as a vehicle to do what President Biden and Vice President Harris are threatening if the court were to take up Dobbs versus Jackson Women's Health and overturn Roe versus Wade. What exactly are these pieces of legislation? Well, the Equality Act has two particular provisions that are relevant. The first is its definition of public accommodations. It forbids discrimination on the basis of sex, including sexual orientation and gender identity, in places of public accommodation. If that sounds familiar to you, it echoes the civil rights statutes that have prohibited racial discrimination in places of public accommodation and other forms of discrimination as well. The bill defines public accommodations to include any establishment that provides healthcare services, and it's not just limited to physical facilities and places. The term also of sex includes pregnancy, childbirth, or related medical conditions, and states that pregnancy, childbirth, or a related condition shall not receive less favorable treatment than other physical conditions. There's also a provision that governs federally funded programs and activities. It forbids discrimination based on sex, including sexual orientation and gender identity. That particular provision, of course, is the provision that has been most hotly debated in the press. But its implications for abortion have also been noted by a variety of groups, including the U.S. Conference of Catholic Bishops. In any program or activity relating federal financial assistance, the term sex is again defined to include pregnancy, childbirth, or a related medical condition. And it requires that those items not receive less favorable treatment than any other physical condition. In other words, abortion would be considered an equally legitimate and appropriate form of treatment or care for a pregnancy as prenatal care and delivery. The U.S. Conference of Catholic Bishops points out why, although not expressly including the word abortion, the Equality Act actually poses a substantial threat of expanding abortion and increasingly federalizing the issue. A memo from the Catholic Conference says that for years it's been an accepted predicate in federal bill drafting related to forbidden discrimination based on sex must have an abortion neutrality provision to blunt any inference that non-discrimination requires the provisions of abortion. Title VII of the Civil Rights Act of '64 and Title IX of the Amendments of '72 are illustrative. Both titles forbid discrimination on the basis of sex, and both titles have abortion neutrality amendments to mitigate the claim that the prohibition requires a covering entity to provide abortions. The fact that abortion neutral language appears in these particular titles shows that Congress knows how to exclude abortion if that's its intention. And the failure to include them in the Equality Act suggests that abortion would be a required service. The same reasoning and the same conclusion applies to the bill's non-discrimination provisions as applicable to federally funded programs and activities. Indeed, abortion advocates themselves are currently reading the federal funding provisions of the bill to permit women to successfully challenge the denial of abortion. So here we have an act that's already passed one house of Congress, that's been endorsed by the president and the vice president, so there's no question of it being vetoed, that is moving its way to the Senate, that while not directly using the word abortion, is anticipated to require abortion to be treated as ordinary reproductive health care. There's a second bill pending in Congress, though, that I'd like to mention before we open this up for question, and that's H.R. 2975, the Women's Health Protection Act of 2019. Before I say any more, I should indicate that my comments on this are based in part on the fact that I testified against this bill as a private individual and an expert in the area of abortion law in a congressional committee that was reviewing the bill. This bill prohibits state and local governments from imposing certain burdens on access to abortion services. Specifically, state or local governments cannot require, and the language of the Congressional Research Service identifies these in their summary: unnecessary tests or procedures in connection with the provision of abortion services. Now you see that next part of this bullet point is in brackets because it's language that I'm introducing that's not in the summary provided by the research service. Examples that this appears to be directed at are ultrasound requirements or a physical exam for prescribing mifepristone, which is an abortion medication that, in fact, recently was attacked by the American College of Obstetricians and Gynecologists in litigation, demanding that no physical exam could be required prior to prescribing that abortion pill due to the conditions of COVID. The U.S. Supreme Court, however, granted a stay to the lower court enjoining the FDA from requiring physicians to continue to comply if they were going to maintain their prescribing privileges. So the ultrasound requirements also are particularly common, and the literature from the abortion industry indicates that it is a very common practice of abortion providers to provide an ultrasound prior to performing an abortion for two reasons. First, because it ensures that the pregnancy is intrauterine and not ectopic, not in the woman's fallopian tubes, which would pose a threat of severe injury or death if it were allowed to progress. And second, because it's the most accurate basis for gestational dating, which helps determine which method of abortion should be used in order to successfully terminate the pregnancy. Both of these protections, the requirement of a physical exam before the prescribing of the abortion pill, or the requirement of an ultrasound prior to the performance of an abortion, would be in violation of the Women's Health Protection Act should it pass. The same health provider who provides abortion services and these tests or procedures. You could not require doctors, for example, to engage in the informed consent dialogue with the patient rather than some trained other employee of the abortion provider. That requires providers to offer medically inaccurate information to patients during abortion services. Now, this is a hotly disputed phrase, and currently we have pending the American Medical Association's lawsuit against the state of North Dakota, where that state requires that physicians inform women that once a medical abortion or a drug-induced abortion is initiated, that it is possible that that process can be reversed through other medications, and that the pregnancy can be successfully completed through a live birth. The American Medical Association is demanding a ruling that that is unconstitutional because it lacks adequate evidentiary basis. So similar laws to that would be in violation of this federal law if passed. Providers to refrain from prescribing certain drugs, or to have certain hospital facility transfer agreements, such as was at issue in June Medical Services, or to require one or more medically unnecessary in-person visits. Again, we're back to the case against the FDA, as well as state statutes that require a waiting period prior to the performance of abortion, or for patients to disclose the reasons for seeking abortion services. And that's directed, of course, at statutes that would prohibit abortions in cases where they are obtained solely for the purpose of, solely on the basis of the unborn child's sex or race or disability. A case that the Supreme Court so far has declined to hear over a stinging dissent of Justice Thomas recounting the history of discrimination in relationship to abortion. They also indicate that it would provide the Department of Justice, individuals or healthcare providers may bring a lawsuit to prospectively enjoin a limitation or restriction that's prohibited by the law. And if such a lawsuit is brought, and here's where the lawyers will understand the radical nature of this bill and how much it expands beyond the current abortion jurisprudence of the United States Supreme Court. The bill further requires the government defending such a limitation, like an ultrasound requirement, like a physical exam requirement, to show that one, this particular requirement advances the safety of the abortion services or patient health. Just think about how hard it is to prove whether various aspects of COVID prevention are effective or not. Yet the state now will have the burden of proof to show that it advances the safety of women and that such advancement cannot be met by a less restrictive measure. That last element, the lawyers in our audience will recognize the least restrictive means test, of course, is the highest test that the court imposes only on those sorts of statutes that appear to conflict with a very limited number of protections. Race-based restrictions are the sort of restrictions that would be subject to this least restrictive alternative requirement. In fact, in constitutional law, many students have heard the old saying that the sort of strict scrutiny that this particular element involves is fatal, in fact, to the legislation. So this legislation already has 217 members of the House of Representatives that are co-sponsoring it. And in the Senate, prior to her election as Vice President of the United States, Senator Harris was a strong proponent of this act. I believe this is the bill that President Biden and Senator Harris are threatening passage of if Roe versus Wade is reversed. And even in the absence of reversal of Roe versus Wade, if Roe versus Wade is retained, there will still be very strong efforts to pass this legislation in light of the simple fact that no federal law related to abortion has ever been struck down by the US Supreme Court. And the fact that the expectation of experts who both desire and who are opponents of striking down Roe versus Wade is that if Roe versus Wade falls, it will be on the basis that it is not an issue that is of direct concern of the federal Constitution, and that the states are free to legislate in the area as they wish. This would preempt the possibility that any states that believe that the unborn should be protected in law from the moment of fertilization, or at least the moment of implantation, that none of those states could legislate protection for the unborn, absent a showing that it is also enhancing the safety significantly of the woman, and that the advancement of the woman's safety cannot be met by less restrictive means. And so with that, I'd like to stop my screen share, and I'd be happy to answer any questions.
Thank you, Professor Collett. I'm just going to pull up the Q&A here. Okay, we have some questions coming in. I'll just start with this one here. It's, hypothetically, if Roe v. Wade was overturned, and it's a due process question, how would you respond to instances where, if it went to the state level, some states would be more strict on abortion laws, others would be looser. And how would you respond to the possible inequality of women who have means to travel to states that do allow abortions versus women who do not have the financial means to travel out of state for an abortion? And would this have an effect on due process?
So the fact that states vary in their determinations and policy judgments is inherent in our federalist system. And the court typically is very unsympathetic to claims that a state statute is rendered unconstitutional simply because another state has made a different policy decision. So, for example, in the Glucksberg case, or Vaco versus Quill, the two cases regarding physician-assisted suicide, we now have states like Washington and Oregon where physician-assisted suicide is available. But we have other states, like the state of Minnesota, where it remains illegal. And that has not been held to be a federally constitutional mandated change in Minnesota law. It's simply one of those things that is a natural facet of the differences between state policy judgments and the ability of citizens at the state level to have the laws represent their values and beliefs instead of some sort of national uniformity.
Thank you. Okay. Another question here. In your opinion, what is the best way to stop abortion in the United States? Not just by overturning Roe v. Wade, but all abortion.
Well, and that actually, because of our time limits, is something I want to address in the last section of the law review article that I'm writing on this topic, which is that the abortion debate is changing dramatically based on technological advancement in the treatment of children who are born prematurely, as well as the changes in the methods and practices of abortion providers. So, for example, there are, in the Danforth case, the United States Supreme Court put the outer edge of viability when a state could prohibit abortion, generally subject to the life or health of the woman, although health, of course, is the exception that swallows the rule. But nonetheless, they put it at 24 weeks. We now know that there have been successful births of children at 21 weeks that have been successfully sustained, although typically the real debate is around 22 weeks for viability. So viability is, the age of viability is declining. And Justice O'Connor predicted this in some of her abortion jurisprudence. So that's one aspect, that we will see an increasing number of children that can be delivered prematurely, thus allowing the woman to terminate the pregnancy that she doesn't want, while preserving the right of the child to continue its development into a healthy, happy adult. And that's really what Larry Tribe calls as sort of the clash of absolutes. We have the right of the woman to be free of unwanted pregnancy, and we have at least a putative right of the child to continue its natural development. And prior to viability, you can't accommodate both. You just can't. And so, but as viability, the age of viability declines, we can accommodate more and more of that. The other development, though, technologically, is the advent of these medical abortions, the abortion pill and its ability to be used. And while it's much more heavily regulated throughout Western Europe, in the United States, abortion activists are pushing hard to virtually get it to an over-the-counter drug. And yet we know that because of the way that mifepristone and misoprostol work, that severe hemorrhaging is a potential adverse effect. In fact, it can be so severe that the FDA has black box warnings on it, and that's why they require it to be administered by a physician that has prescribing privileges and who is capable of treating the woman should it be an ineffective abortion and not terminate the pregnancy. They have to be capable of a surgical abortion, and they have to be able to treat the woman because of the potential hemorrhaging after that. So I think to eliminate all abortion, there's going to have to be a change of heart, not just a change of law.
Okay, another one here. So there are pro-life advocates that read the 14th Amendment as precluding abortion based on an originalist reading. And the question is asking, are there any justices on the court who might be sympathetic to such a reading of it?
Yes, I think so. I think Justice Clarence Thomas might well be sympathetic to it. Justice Alito, possibly. Gorsuch is a little harder to take the measure of, because while he is, of course, a former student of John Finnis, who has a preeminent Oxford legal scholar who has taken that position, his opinion in Bostock regarding Title VII and inclusion of transgender individuals, while claiming to be originalist, is a very odd originalist statutory interpretation, or at least a strict statutory interpretation. So I don't know where Gorsuch would come down. People speculate about Kavanaugh, and they certainly speculate about Barrett, But Justice Kennedy himself was a weekly communicant in the Roman Catholic Church that accepted the humanity of the unborn, but felt that his position as a jurist required him to take a much more positive approach.
Okay. Someone is asking, what is the status of the Minnesota abortion law litigation?
At this point in time, the Attorney General is in the process of discovery with the plaintiffs, and he has vigorously fought against intervention of any of the parties that might assist him in defending the Minnesota laws. I should also say, for purposes of candor, that I was one of the lawyers that the Minnesota Senate had retained for purposes of intervening, since it is the only part of Minnesota state government at the moment that has pro-life majority. Of course, Attorney General Ellison, while defending the Minnesota statutes, is actively attacking other states' statutes through a variety of amicus briefs. And that was part of the argument for allowing the intervention of the Minnesota Senate. But the trial judge sitting on the case declined to allow the Senate either permissive or mandatory intervention.
A lot of questions here. This is good. If Roe were overturned, would abortion become a crime? And if so, what sort of criminal penalties would be imposed? You know, could doctors, nurses, etc., mothers and fathers be imprisoned?
I am so glad for this question. So whoever wrote it, thank you very much. Because the simple fact is that if Roe versus Wade is overturned on the basis that the most optimistic among us generally believe it's going to be overturned, which is simply this is a matter of state judgment, an abortion neutrality position, essentially, of the federal Constitution. In that case, we know for a fact that there are many states where abortion will remain legal, and not only remain legal, but be legal through all 9 months of the pregnancy, like it is in Minnesota. While we did at one point have a limitation on abortion at viability, it was struck down in 1975 by a federal district court. And advocates have not been able to get even a limitation on abortion arising at viability through the Minnesota legislature and signed by the governor. The last time we had that chance, we got it through the legislature, but the Governor Dayton vetoed it. So, and then we've got New York, of course, where the governor not only signed it, but celebrated it by lighting up the Empire State Building in pink. We have states like Virginia, we have states like Illinois. So the idea that the reversal of Roe means that abortion is going to be a crime in all 50 states in the union is simply false. Unless, in the highly unlikely case, the court does find that the unborn child, at least after implantation, is a person for purposes of constitutional protection, which is not completely outside the realm of imagination. I mean, if US corporations can be people, it does seem a little odd that the unborn child, at least at viability, isn't a person for constitutional protection. But even that doesn't answer the question, because there are a couple of other cases that are deeply troubling, whether you're pro-life or pro-choice, in which the US Supreme Court has held that there's no constitutional obligation of the government to protect against private acts of violence. And that's exactly what abortion is. It's a private act of violence directed toward terminating the pregnancy and killing the child. And so if there's no constitutional obligation to protect people, then there would not be any correlative obligation to protect the unborn, unless there's an equal protection argument that we can only protect infants and newborns if we protect the unborn. But I would expect that to be a pretty vicious legal fight.
Okay, I think we have time for probably one more question here. So this was a follow-up question to the first one. They are seeking further clarity. So It was regarding the income inequality of potentially pregnant women.
The interstate travel question.
Yep. And then the question is, pro-choice advocates use this argument all of the time. Can we pro-lifers get a better defense that closing clinics restrictions such as waiting periods is not racist, classist, etc.?
Well, I think we actually have a pretty good defense of that already. So I'm not exactly sure where they're trying to, what they would like me to help them think through. But I will say that what we're seeing when you look at the business side of the abortion industry is consolidation, just like we're seeing in other things. And when Walmart comes to town, guess what happens? The little stores close. Well, when Planned Parenthood comes to town, guess what happens? The little clinics close. Think of the size and just the square footage of the abortion clinic in St. Paul. It's one of the largest in the country. Houston's another place where they have a gigantic abortion clinic that's owned and operated by Planned Parenthood. And yet, those are the very organizations that are suing, saying, oh, you're closing the abortion clinics, when it's a natural market mechanism. In fact, I'm proud to say, one of our St. Thomas graduates has written a terrific article on just a market analysis of abortion and why, if we simply look at the business practices of the industry, that there will be a consolidation, there will be a closing of clinics. And the fact that they're not in rural areas should certainly not be as of great concern as the fact that we have declining numbers of emergency rooms in rural areas. Rural health is in a state of crisis, but I sure would rather see emergency rooms there first.
Okay, we are at time. So want to thank you once again on behalf of the Murphy Institute for everyone joining the webinar today. Again, this is approved for CLE credit, so please follow up with Michelle to obtain that, and have a great weekend.
Thank you for having me. Bye-bye.